Okay, so let us get back to where we were. So we were discussing, I'm going to start reading the Mishnah and the Gemara in a minute. Let me just finish up a little bit more of what we were discussing previously. So we'll go back onto the Mishnah and Gemara in a minute. But basically, the theme of the first parak, the first theme of the first parak, is how to resolve disputes when you don't have witnesses and you don't have hodas baldin kamedim dami. So basically, you are in a situation where you are weighing, one person's version of the events against another's, right? And obviously,
And
that's
both
difficult.
and both of them are holding on. So both of them have
So,
that's
so the
that's
broad topic, that's the question. I mean, the case of the Mishnah is where both are holding on. The question is whether the holding on is a crucial part of the yachloku or not. And what about other solutions? So we'll get back to that in a few minutes. But as we already previewed, there are other ways to solve, um, a dispute. One way is to divide. The other way is to, withhold any kind of solution, to ensure that you don't, benefit the guilty, and to incentivize the guilty party to admit, their wrongdoing, so at least they can salvage maybe their part. So that's the question of what we call Yehemunach Hachiyav Eliyahu. There's also in Bava Basra a solution called Kol Dalim Gavar, which means that whoever is stronger wins. We'll discuss that, obviously. Um, Sometimes there's a solution called Shuda Daini. Shuda Daini means that the judge or the judges determine the winner on the basis of what? That
the
obviously.
machlokas, intuition or
So
halacha.
we'll get to that exactly. So the point is that there are other ways to solve a problem, and even in Yachloku, there are three different models of Yachloku. One is Shnaim Osa Batalis, where two people are holding on to the same object at the same time, Yachloku. The other is Shtei Shtaros Hayotzim B'Yom Echad. That's a situation where two people come to court, each one brandishing a contract that establishes that a piece of real estate was sold to them, Tuesday morning at 9 a.m. or that to go into effect the sale, let's say, at Tuesday morning or Tuesday, let's say. But each one has a contract that equally says that on Tuesday, they become the owner of this single field. So that's called Shtei Shtaros Hayotzim B'Yon Echad, two contracts that come out on the same day. And they're also that's a yachloku according to Rav. That's the argument whether you say shuda daini or whether you say yachloku. So that's a second example of yachloku. There's a third example of yachloku, and that's what we call. We're going to discuss all these. Mammon amutal b'safek. Mammon amutal b'safek is a case where it's not knowable one way or another, and often the litigants don't know either. They don't really have a definitive, opinion. They're shemba v'shemba, not bari v'bari. In not all
Like the
cases, but
calf that's born out of sight.
right, like let's say a Vlad, a calf, is born to an animal that was remotely acquired, by one party, or does it belong to Ruvain? Ruvain sold it to Shimon. He sold it in such a way that no one was physically there at the moment of the mechira. So by the time he comes to claim his new, prize cow, there's a Vlad, there's a child, there's a calf, and it's not clear whether the calf, assuming that you can't tell based on the size or other aspects, it's not clear if it, was born prior to the transaction or after the transaction. So that's called Momen Amuta B'Safek. Sumcha says that that's also Yachloku, but that's a Yachloku certainly B'Torah Safek, because usually even the parties themselves, Ruvain and Shimon, don't know. They weren't there. They did this kinyan remotely. So even Yachloku itself has three different models, if you will. So there are many ways to resolve disputes. And part of the question is, what's the best way? What's the preferred halachic way? And you can understand that that's like a major, um, that's an important question. It's not a technical question. It's a fundamental legal rights, and legal preferences question. Is my first concern to minimize loss to the innocent party, or is my first concern to make sure that a cynic gaming the system, doesn't succeed?
Isn't it a broader
First,
question of whether the societal issues are more important than the individual issue?
I'm not necessarily.
Because if
It
you're
might be an
interested,
objective. I
if,
mean, it could be a societal deterrent issue, but it
in
doesn't
other
have
words, if you're interested in society, then you want to punish even the correct guy by saying, unless if nobody gets anything unless I get to the truth, because I don't want people to think they can get away with it, which in a way punishes even the honest person, but he's also getting nothing. But
right. But I'm just saying, even from a justice position itself, it's an open question. You don't want the judicial system to be gamed by people, not just because you want to discourage them from doing it, but because it's also inconsistent with the integrity of the system itself. So there are really two aspects to it.
we have
Uh,
that in other cases where we don't want the Bezin's reputation to be tarnished. We many times make.
right. So things like sometimes we prefer what we call a CLOOK resolution, which is for Bezin to say, listen, we don't have the means to solve this problem. Let some sort of informal process take place. The reason why that's sometimes preferable is because it doesn't detract from the reputation and the integrity of the Bezin. So what I'm trying to say is there are a number of different factors here, which you can imagine that depending on the nature of the philosophy of your legal system, that you are going to give precedence to one over the other or the other. So to take a step back, what I was trying to explain in a bigger way was the phenomenon that the Rambam counts a lot of the details of Choshen Mishpat in Minyan HaMitzvos. And others found that very troublesome. Like, why does he count? They're not mitzvos. Things, normally we think of a mitzvah as do this, right? Refrain from doing that. There are commandments and prohibitions. But these aren't commandments and prohibitions. These are laws. These are how to treat, what to do if X happens, what's the law? What are people's rights and privileges? So should the Rambam count that in the Minyan Taryag? So the Ramban was basically saying, this is what we read last time, in his comments at the end of the Shoroshim and Sefer Mitzvos. Ramban was saying, as far as I'm concerned, theoretically, I would have been happy with one mitzvah, because the pasuk says in Shoftim, Titan L'Chabachol Sharecha, appoint judges in all your locations, right? And then the pasuk ends, and it's and then the pasuk ends, V'shaftu esa'am mishpat tzedek, and you should judge the nation mishpat tzedek, law, just laws. So the Ramban says, my inclination would be that a lot of these Choshen Mishpat mitzvos that the Rambam counts are just under the rubric of V'shaftu esa'am mishpat tzedek. And if you ask, what does mishpat tzedek mean? So he says in Achanami, we have to work backwards. Whenever the Torah reveals what the laws are, we can reconstruct from there that that's tzedek, because the Torah is just. So, and the Torah tells us to be just. V'asisa yashar v'hatov. So the Ramban says, if it were up to me, I think I would count all these I wouldn't count 4 Nezikin and 3 Shomrim and Toain Vinitan and Malva Velova. Most of them I wouldn't count anyway. But I would count them under the rubric of, Vishoftu Sa'am Mishpat Tzedek. I should mention that Rashi and the Rambam are of the opinion that the words v'shafto esa'am mishpat tzedek don't mean that you should, um, judge everyone justly, or apply justice, in your decisions. They actually refer to the beginning of the pasuk. Shoftim v'shotrim titen l'cha b'chol sha'arecha, meaning
That's that the
you are
system should be
obligated to
just.
appoint judges. So the end of the pasuk says v'shoftu esa'am mishpat tzedek. So the way Rashi and Rambam both happen to
The
read the
result
pasuk
of
is
what you did.
make sure when you make these appointments that you make them in an idealistic manner, namely that the people that you're appointing have integrity, they have competence, so that the people that you're
Like
appointing,
Yisrael suggested.
what?
Like Yisrael suggested.
Yeah, exactly.
Done
So,
Butza, and
so
people like
according to Rashi and Rambam, this pasuk v'shoftu sa'am mishpat tzedek is just a continuation of shotim v'shotim titin lecha b'chol sharecha v'shoftu sa'am mishpat tzedek. Who should you appoint? People who have the knowledge and the integrity, to judge justly. But the actual implementation of just law, according to Rashi and the Rambam, that's not included in that
but
pasuk. But the
isn't it
Ramban thought it
in
should be.
effect?
Why did the Ramban think it should be? One more second. Because he said that when it comes to dinim of B'nai Noach, the Noahides have 7 mitzvos, right? One of them is dinim, and that's one. It's not, it's not 100. So if the Noahides dinim is all compressed, all encapsulated in one mitzvah, then why can't the same thing be true for Klal Yisrael? Even though he previously asked the same question about Gilead Rayos, about illicit relationships, and about Avodah Zarah, idolatry. But there he answers, he says, yeah, but that was all pre-Matan Torah. After Matan Torah, when the Torah formulated Arayos, if you look at Acharei Mos and Kedoshim, it was very, specific. It has a separate lav. It says don't do this and don't do that and don't have a relationship with this person, don't have a relationship with that person. So pre-Matan Torah, maybe all Gilead Arayos was a principle and applications. And post-Matan Torah, the Torah taught us something new, and that is that while Dinei B'nai Noach is a broad, idea of having, acceptable relationships, for Dinei Yisrael, each of these constitutes a separate egregious violation. We can appreciate that because last year we learned Yevamos, those of you who were here. And in Yevamos, right, we tracked some of these, relationships. And we noted, for example, let's say a daughter-in-law, Kala. We noted that the Torah, when it speaks about a Kala, speaks about her in 2 ways. It speaks about her as the wife of your son, don't have a relationship with your son's wife, and also as your daughter-in-law, which are the same thing, admittedly, but they're not the same conceptually, meaning, number one, it violates, the your son's dignity and sanctity if you were to, enter into this kind of improper relationship. And number two, there's an incestuous element, even though there's no blood relationship, because your daughter-in-law is still, a direct connection through your son, but through your son, a direct connection. So this is a great example, the things that we kind of spoke about last year, and Eshes, Achiv, which of course is the Yibum issue. Like you can have a sister-in-law, the wife of your brother, and that's a terrible violation of your brother. And for that very reason, namely, in the context of Yibum, it becomes a mitzvah because he doesn't have any children. So you're not trying to violate, his privacy and sanctity. On the contrary, you're trying to provide an ongoing, legacy for him. I don't want to do all of the Yibamos again, but my point is that you see the example. What's 1 second? The example of Gilead Rayos tells you that Jews and non-Jews can have overlapping mitzvos, and the specificity and the individualization, in other words, of the Isurim highlights a much more aspirational like approach to these issues. It doesn't just say, oh, have only proper relationships. It's spelling out, what specifically is problematic in Enadoma Eshasish to Eshasach to Achosishto to Kaloso, to Eshes, Aviv, and so on and so forth. So Ramban ultimately comes to the idea that he understands why for Bnei Noach all of Gilead Rayos is bundled into a single lav, and at the same time for Klal Yisrael, I don't remember the number.
But
it's 25 different Isurim.
Isn't this consistent with the Ramban's outlook on Kadoshim Tiyu? In other words, it's okay for the rest of the world to say that basically they shouldn't have a certain kind of relationship, but they don't have to rise up to the level of Kadoshim Tiyu. For that,
I think that's a great,
need the specifics.
100%. Very good. Excellent. So, and I think it is all connected. So that's how the Ramban ends up about, he says, okay, I'm okay with Avodah Zarah and Gilead. But with regard to Dinim, for some reason, he didn't get there. And I think the reason is because the Torah never says about Dinim, don't do this, do this. It just tells you what the facts are. So the Ramban thought, oh, that's part of just having a just system. But in the end of the day, the Ramban did not accept this view, even though he doesn't tell us why he changed his mind. How do we know that he changed his mind? Because the Ramban, like the Rambam, accepts that there are 613 mitzvos. The Ramban in Sefer Mitzvos tells us which ones the Rambam should have omitted and which ones he shouldn't have omitted. And he doesn't change,
number
the Nezikin ones. Otherwise he would have had to replace another 50 odd or 60 mitzvos, and he doesn't. So that's why the Tashbates, the Rashbats, in his Zohar Harakia, he mentions all this. I'm just going to read the line for a minute. He says, I, like the Ramban, think that it makes a lot of sense to say that all of the dinim of Choshen Mishpat are one. This is, I think, on page 6, or on page 5, sorry. So this is the Rashbats in Zohar Harakia Os Tesvav. V'ladun b'dinei mamanis, he says. I think it's page 5 or the bottom of 4. It starts with the words Rashbats. Everybody have that? Yes or no?
Bottom of 4.
Okay, bottom of 4. Excellent. So it says Rashbats Zohar Harakia Os Tesvav. So this is what he says. V'ladun b'dinei mamanis, to adjudicate, justly matters of dine mamanis, meaning monetary law, civil law. He mitzvah aseh, shenemar v'shaftu asa'am mishpat tzedek. Like we said, right? V'chein perik shnei daine gzelos. In Ksuvas, the Gemara at one point talks about a certain case where they say, Amru hayaseh v'hayaseh. You have to choose between two esen, al dine mamanis u kavod Torah. Like there's a clash between the principle of kavod Torah and the principle of dinim, or proper application of dinim. They call it hayaseh v'hayaseh. The Rashbat is saying they shouldn't say hayaseh. They should say hay, shloshim esen. Okay. For Ramban, he says hichnis b'mitzvah zu kol dinim. The Ramban, in his comments at the end of the Sharoshim and Sefer Mitzvos, included all dinim as one obligation of V'shaftu Sa'am Mishpat Tzedek. Ben knasos, whether we're talking about penalties, dine chavalos, personal injury, dine onsim, things that happen, accidentally or coercively, dine mamanis kulam, shezeu b'klal, V'shaftu Sa'am Mishpat Tzedek, says the Ramban. B'nistayea bazeh, and he found reinforcement, says the Rashbats, from the Gemara in Sanhedrin that says, Mimasha Amru, Eser Mitzvahs L'Stav Yisrael B'Mara, 10, and that the 7 of Bnei Noach and 3 more, Harei Shechnisu Kol Adinim B'Chal Mitzvah Achas. So that means that implicitly that Gemara is telling us that all of civil law is bundled in one mitzvah. So then the Rashbat adds, Aval b'sof dvarav, ani roeh shu maskim leminyono shel harav zal, meaning the Rambam. He says, however, it's an unmistakable conclusion that even though the Ramban tells us that this is what he thinks, that he didn't follow through with it. Because in the end, he mostly embraced the Rambam's minyan. Otherwise, I say he would have had to replace another 50, 60. I don't know the number, but it's not hard to figure it out. But,
Wasn't Mara
dozens and
before
dozens.
Matan Torah?
What?
Wasn't Mara before Matan Torah?
Yeah, no. So what he's saying was,
So
in
anything before
Mara,
Matan Torah is not relevant, really.
no. What he's saying is, in Mara, it's described as one. And in Matan Torah, unlike Arayos and Avodah Zarah after Matan Torah, which were then like broken up, but broken up with the words, of a mitzvah and an iser, lo this or asay that. This wasn't. So he says it remains. The Ramban was saying it remains that way, but obviously he doesn't feel that way in the ultimate conclusion. Shehu mone kol achas me'elu mitzvah kamoshes bar b'mashayavot. Obviously, in the end of the day, he acquiesced to the Rambam's system. And then the next piece is Os Nun Gimel, which
Maybe
he may
he had
reference
no
to.
choice because he had to come up with a 613.
Yeah, exactly. Yeah, that's how we know he didn't follow through with that. Like he would have been enormous pressure. He would have had to replace, 40, 50,
Yeah.
60 mitzvahs. So Akashi Hizkir Shuv Ramban, the Rashbat says that after mentioning the Ramban and the Rambam, and the fact that the Rambam counts separately Gimel Shomrim, Dalad Nazikin, Mekach Memkar, Toin Vinitan, Ganav, Dalad Ovs Nazikin. So then he adds the following sentence, the Rashbats. Kol Elu Mitzvos HaTliyos B'Mamon, all of these Mitzvos HaTliyos B'Mamon, Shem Eser, at least these 10, Einon Etzli Ela Achas. I, the Rashbats, think that they're all bundled into one. Behu Lishbot B'Tzedek, the common denominator of which is to judge, righteously.
How does he come up with the other mitzvahs to make 613?
So he has his issue. He doesn't necessarily believe in 613. He's really working with the count of Reb Shlomo, even Gabriel, so he has a little more flexibility. The Einlon Litzedek Acher Elamash Amrato. That's a very nice line, which the Ramban kind of says earlier. Tzedek is defined by backwards, reconstructed from Torah law. The assumption is that Torah law is tzedek.
Isn't that pasuk a cause and effect? If you make shortrim, then you're going to have mishpat tzedek.
Say that again?
Isn't that pasuk cause and effect? If you make shortrim, you're going to have mishpat tzedek.
No, that I'm saying Rashi interprets and Rambam interprets that, v'shofto sam mishpat tzedek is connected to shoftim v'shotrim, meaning appoint judges.
How do you have mishpat tzedek if you have a system that has shoftim, invariably you're going to have mishpat tzedek.
Right, but you can still have two different mitzvos, one to appoint righteous judges and the other to follow scrupulously, the rules that give you a just solution. I mean, look, our problem, we're trying to figure out what's a just solution in Shnai Moksa B'Talis, or Shtei Shtar Seyotzim B'Yomachad. So that's kind of what we're at. So the Rashbats holds strong with this, but points out that the Ramban obviously gave in. So what I want to explain is that, even though he doesn't say it, in the end of the day, if you look at the Rambans all over his Perush al Torah, you could totally appreciate why he gave in. So the Ramban everywhere in Shoftim and in Mishpatim and in Kedoshim. I'm not going to read them because I want to move on, but the Ramban always has this idea. The Ramban in Parshas Mishpatim, for example, says explicitly that it's not a coincidence that we signify Dayanim Smuchim, meaning authorized judges, by the word Elohim. It says, V'nikra Bal Habayis El Elohim. So the drasha is Elohim means a Dayan Samuch. It doesn't mean the Rabbanu Shalom. It means a human judge. That's why you can say the word Elohim. V'nikra Bal Habayis Elohim. Elohim. It says Elohim in these contexts 3 times. The Gemara says in Sanhedrin, that's how we know you need 3 Dayanim Smuchim, meaning who are credentialed with the authority of smicha for Dine Mominus. So the Ramban in Parshas Mishpatim says, is it a coincidence that the word that signifies a Jewish judge, is the same word that in other contexts, and even in this context, it's a little bit confusing, also refers to the Ribono Shel Olam? So the Ramban says no, because the Ribono Shel Olam oversees the judicial system. There's extra siyata d'shmaya, divine providence, for judges who are qualified, who have integrity, and who are pursuing justice. Again, obviously it's not infallible and foolproof. We can't. But as a general statement, the Ramban, says this numerous places that the Ribono Shel Olam has special divine providence, to assist sincere judges. So the Elohim are assisted by and are the ambassadors of, and are protected by Elohim. That's the Ramban's comment. But the Ramban in Mishpatim, this is how he explains also. Again, we have a prohibition to go to non-Jewish courts if you can achieve satisfaction in a Jewish court. That's based on the pasuk in Mishpatim, Ela Mishpatim asher tasim lifnehem v'lo lifnei arkaus, that you're not supposed to go to non-Jewish courts if you can achieve satisfaction in a Jewish court. So what the Gemara says, and the Ramban elaborates this in his own way, Rashi mentions it also, afilu kishadineim kedinenu, meaning even if the non-Jewish courts have the exact same laws in a certain area that we do, you still can't go to our coast. So that's obviously a very challenging position. If the laws are the same, so you're going to get the same result, why can't you go to a non-Jewish court? If the laws were different, the results were different, we'd say, from a Jewish court, from a Jewish jurisprudential point of view, there's a miscarriage of justice. But if the dinim are the same, what's the problem? But the answer is, I think, even for the Ramban, or maybe especially in the end for the Ramban, is that when you have a Choshen Mishpat, civil law, Jewish civil law, which is part of the larger system, which includes Kachim and Taros and Zraim and Nashim and Moed, it's even those laws that are the same take on a new coloration.
I don't even understand the question. Just because they keep the laws, I mean, you have to be a Talmud Chacham or a judge to judge. I don't understand if all the Goyim keep our laws, therefore we can go to a non-Jewish court. I'm
we're
missing
saying the
concept.
opposite.
We're
explaining why they can't, why you can't.
Right. So I don't understand the question. Why would we?
Well, the question is simple. The question is,
I mean, just because they have laws, they don't know how. They're not Talmud Chacham. They don't know how to interpret laws.
Let's say you have scholarly judges if the laws are on the books.
A scholarly judge is compared to a Talmud Chacham now, to a real judge. I'm saying
not every
case. If Albert, I mean, even the smartest, there's something to a Jewish. No.
So what there is
Micha. I mean, why don't we wipe out
that
and you go to any smart guy and they can give you
I would say that if what you want, this is exactly the issue. If what you want, technically is the legal answer, then in many cases you're going to get the same answer as long as you have very competent.
I doubt that, because even in legal there's conflict.
Well, let me finish this.
You have to be a Talmud Chacham to answer.
Right. So, but if what you're looking for is, in addition to the technical legal point, is a spiritual dimension, to the law, then you need a Talmud Chacham. So that's exactly the point. The point is that Choshen Mishpat's Jewish civil law, of all areas of Jewish law, is the most pragmatic, and it's the one that overlaps the most with other cultures and societies. And this is the point I was trying to make last time also. The Ramban himself in Parshas Vayishlach is of the opinion that dinim is an extensive legal system. And according to the Ramah in a tshuva, we prefer that it be Jewish civil law. We prefer that non-Jews, all things being equal, employ Choshen Mishpat for their dinim. So what differentiates them?
We would like Goyim to use our law. Is that what Rabbi is saying?
we would like them to use our civil laws, according to the Ramah's reading of the Ramban.
So
So let
we
me just
would,
highlight it. So the
yeah.
Netziv, in his commentary on the Shiltos, disagrees with this Ramah. He says it cannot be that the Ramban view is that, dinim is not only an extensive, comprehensive legal system that, addresses the same areas that Jewish law addresses, but that it actually is mostly, let's say 90%, 80%. What we would prefer is that it actually 80% be actual Jewish law. He says, because then why is there a prohibition of arkos? Moreover, we say in in Tehillim, and we say it in Tefillah every day, in Psukkot Zimra, or Lo Asachein Magid Zorav Yaakov, we say, Chukav Umishpatav Yisrael, Magid Zorav Yaakov. He, informs Yaakov, Chukav Umishpatav Yisrael. His laws and judgments are conveyed to Klal Yisrael. Umishpatim Bal Yidaum Halaluka, right? So this is the difference in Tehillim. What we're saying is that Jews have a Halaluka kind of a law, Baruch Hashem, and we're contrasting it with non-Jewish justice. So then Netziv says, if the Ramban, if according to the Ramah, the Ramban thinks that the preference is for non-Jews to have Jewish civil law to adjudicate their own problems, then what does that mean, Mishpatim Bal Yida'um Haluka? It's the same law. But the answer, I think, is, just give me one more minute. The answer is along these lines, and that is, when it comes to efficiency, and when it comes to stabilizing society, so that part of the overlap, Jewish law and non-Jewish law share, especially if it's the same dinim. However, there still are differences, and even when those differences are not being applied, the principle behind the differences are applied, and that's why you need a Talmud Chacham, and that's why you need, the framework of Jewish law. So let me explain. So the Gemara says in Sanhedrin, Anaf Nun Vav Beis, that even where there's an overlap between Jewish law and non-Jewish law, there are still differences. For example, Jewish law requires 2 witnesses. A non-Jewish law does not. Rambam codifies these as well. Jewish law requires 3 judges, or in a capital case, 23 judges. Non-Jewish law does not. Jewish law requires hasra'ah. Hasra'ah means that you have to warn the person, and he kind of basically has to sign on his own death sentence. He said to him, "Are you sure you want to do this? Aren't you aware that if you go ahead with this, you'll get the following punishment?" And he's supposed to say, yes. He has to respond, "I understand fully what is at stake. The afal pichein, I'm in. I want to do this crime." There's no din of hasra for non-Jews. The way the Rambam has it, Jewish law requires, all things being equal, that there be a presence, a court presence, not only broadly so you can get access to mishpat when you need it, but what we call b'chol pelech u'pelech u'b'chol ir v'ir, in every venue, that there is, big and small. Non-Jewish law, according to the Rambam's view, Ramban disagrees on this one point, but in Hilchos Malachim, the Rambam says b'chol pelech u'pelech, but not b'chol ir v'ir. So what's the difference? Or, for example, yeah, there are many other differences too. Smaller differences, but differences. So what's the difference? The answer is Jewish law has 2 functions, and Noahide law has one, even if it's the same dinim. The Noahide law is focused on stabilizing society and having a life, a framework in which people can live harmoniously, without what Chazal call, ish es chavero chayim b'la'o, one man swallowing up, the other. People are by their nature, I think we know, competitive, argumentative. They can be unscrupulous in pursuing, material success. And therefore, if you don't have an efficient legal system and a fair legal system, then the chaos is under the support of the fabric of society. Yeah,
Oh,
that's true. However, that's absolutely true. However, Jewish law has that, but it also has another element, and that is the idea of Elohim, Elokim. The idea that there's a godliness in Choshen Mishpat, in some respects, even more in Choshen Mishpat than in other things, because that is the nitty-gritty kind of interface. If you can, have a spiritual component in your civil law, that's extraordinary. So let me illustrate this in one way, and then I'll get back to the Netziv. I think this is the point. So Rabbeinu Yonah in Masechet Avos begins the following way. We say, this is the girsa that Rabbeinu Yonah had anyway. There are different girsas, but al shlosha dvarim ha'olam omed. Right, that's the second Mishnah in Avos, Parak Aleph Mishnah Beis. What's the Gimel thing? The Gimel pillars, Omed. The world stands on three things, three pillars. What are they? Torah, Avoda, Milas Chasam. In the last or second last Mishnah of the Parak Aleph of Avos, the Mishnah says, according to the Girsa of Rabbeinu Yonah, Al Shlosha Dvarim Ha'olam Kayam. The world exists, based on three things. Din, Emes, Shalom. So there's a lot of discussion among commentaries. What's the relationship between the triad of Torah, Avodah, Gemilas Chasadim, and the triad of Din, Emes, and Shalom? Anyways, Rabbeinu Yonah has the following comment. Rabbeinu Yonah says, what's the difference between the first list, which is Omed, Ha'olam Omed, and the second list, meaning the last Mishnah in the first parak, which is Kayim? So the Rabbeinu Yonah says, Omed refers to the purpose, or what, in the world of philosophy they call the telos, T-E-L-O-S, the reason, the final cause, the reason something was created. Why was the world created? What are the pillars of the world? What's the purpose of the world? The answer is it's a framework for accomplishing Torah, Avoda, and Gemilas Chasad. However, Kayam, says Rabbeinu Yonah, that refers to the necessary elements that allow the world to exist pragmatically. And that's Din, Emes, and Shalom. Rabbeinu Yonah goes on to say that Din, Choshen Mishpat, Jewish civil law, is very pragmatic, and that without it, Ishas Chaveiro Chayim B'la'o. He also says, by the way, Kol Da'alim Gavar, which is funny given our issue, which we'll get back to, meaning every might would make right, and people, would just grab from each other. It would be chaos. It wouldn't be a kind of society, which could produce, better things. And therefore, it says Rabbeinu Yonah, Din is different than other aspects of Jewish law. However, the very same Rabbeinu Yonah earlier, this is the one that's not so well known. This piece about Kayim and Omed in Rabbeinu Yonah was publicized by the Tur. Rabbi Yaakov Baal HaTurim, as they call him, the son of the Rosh, who wrote the code, the Tur. He was the Rosh's son. Anyways, he begins Choshen Mishpat, Jewish civil law, by extensively quoting from this commentary of Rabbeinu Yonah in Avos about the difference between Omed and Kayam, and about the pragmatic aspect of Choshen Mishpat. But he doesn't mention that the same Rabbeinu Yonah, even earlier in his Perush on Avos, in Parak Aleph, Mishnah Aleph, comments on the words, the first Mishnah after enumerating the Masorah says, that there were three, Anshe Knesset Hagedolah left us with three things. Asus Yag Torah, Hamidu Talmidim Harbe, but the other one is Hevu Mesunim Badin, which literally means be patient or deliberate, actually, in judgment. So I wanted to look for a second on the same page that we were at Rabbeinu Yonah's commentary. You have that there, Rabbeinu Yonah, Masechet Avos, Parak Aleph, Mishnah Aleph?
Yeah. Hey, Mamu, give it the one.
Okay, so the first part is really not, first part is very beautiful, and I'm going to read it because, we should have not read it. It's a nice piece, but it's the second half that I'm most interested in. So, but bear with me for a moment. What does it mean that you should be deliberate in judgment? So Rabbi Yonah says, "Hey, Marmul Gimel Dvarim have a Masunim Badin." Says limorim horaos leposkin horaos. The leposkin is hadin. To those people who render halachic decisions of all different types, the Mishnah is telling you, Amru lebal yismechu b'machshava rishona. You shouldn't rely on your first impression, like when you're brought information to paskin. You shouldn't paskin right away just based on your first instinct or your first understanding. Ach b'hamtana gedola, instead with great deliberation, ube'iyu nadak, and careful consideration, lebal yitu b'shikol hadas, lest you make a mistake in evaluating. People today are like, boom, you write them an email, they're already, before the ink is dry or the digits are dry, whatever it is, they're already answering you. People they ask you a question, they expect an answer. Toch de dibor. The Mishnah says
everything is instant today.
What?
Everything is instant today.
Yeah, it's crazy, and that's why there's so many mistakes and people, do things that they can't take back. It's a terrible culture. So, ki ha'adam ha'mimaher lehorot, a person who is too quick to render decisions. Listen to this: nikra poshea. He's called negligent, even though he didn't do it intentionally. He meant well. Maybe he was just trying to give speedy justice. You also don't want to delay too much. What do they say? Justice delayed is justice denied. Is that the way they say it?
Something like that. But on the other hand, without due consideration, you devalue the human beings before.
So you have to balance these two things. Just because you meant well, that doesn't make you a shogeg, right? Because you should have known better. Your responsibility is greater. You should have known that somebody in a hurry is likely to make a mistake. Any fallible human being can make a mistake. So whether it's a medical diagnosis or a judicial judgment, etc., anything that's important and complicated, requires serious consideration. That's what we mean. Meaning, if you're too quick, even though you are sincere, that's like mazid. That's like an intentional mistake. Amar Shlomo Ra'isa ish kacham bi'einav tikva l'ksil mimenu. Kmo shamar Chazal hagas libo b'hara shota rasha v'gas ruach. Person is too quick and too self-confident about his ability to render halachic decisions. We have very choice negative description of such an individual. He might mean well, but again, there's a certain responsibility that he has not to be a crowd pleaser and not, to demonstrate, his acumen, by answering too quickly, but, by being careful. It's interesting, the Chazal say, Vishinantam levanecha, for the language of Shinun, Shehe divrei Torah mechudadim bepicha, shemish'alcha al tegamgem v'tomar ela emor miyad. We also have, it sounds like those are opposite statements. Have Masunim Badin and Al Tegamgem V'tomar Ela Emar Lo Miyad. Answer immediately. But in one case, we're talking about Hora. In the other case, we're talking about, you should have mastery over the material. It's also your responsibility. Anyway, L'chein Ha'adam HaMoreh Yesh Lo Lisa V'litam B'davar, a person who is a decision maker should weigh all the sides. Ulahachmitz, from the language of chametz, meaning let it, let it rise and give it time, right? Hamachshava ulishahosa kinyan shamra machmitz in esadin shaydei chimutz v'amtana mosif svara al svaraso upilpul al pilpul. A beautiful language of Rabbi Yonah. With a little extra time, he'll have deeper appreciation and understanding. Ad shiyadin din emes lamito ki b'machshava shniya. In the second, his revisiting of the issue, he will, see it differently and it might illuminate it for him. U'b'inyan zeh Amar Asaf, ki yitchametz levavi v'kil yosai esh tonein. Klomar acharei asher levavi mitchametz, after I give it more time and I sit with the problem a little longer, umitpapel al chachma v'kil yosai, ani mishtonein umitchadeid hasagati ladat, ki belize lo yadati zeh chelki. U'kamosha kasav achrav, ani ba'ar, I'm ignorant v'lo eda, behemos hayisi imach. Batam, okay, so that's point number one. That's just, highlights very beautifully. It's an important principle, and it highlights the responsibility of somebody who renders halachic decisions. But then Rabbi Yonah says something, I think, equally spectacular, maybe more spectacular, and that is as following. Batam al she'omer have a mesunim bedin. Why does it say be deliberate in din? Doesn't say in hora'ah, right, in rendering decisions. Why does it specifically say the word din, which has a civil law, chosha mishpat, in other words, connotation? Says the Rabbeinu Yonah, kedei lahazhir yoser al adinim mishar hora'os, in order to emphasize the significance of hora'ah in the area of civil law, even more than other areas, with regard to what? Shehem ikar godol b'yedias yisbarach. Because civil law, says Rabbeinu Yonah, this is certainly counterintuitive and therefore very profound. Civil law, says Rabbeinu Yonah, not taros, not kodship, right? Not kedusha sazman, not moadim. The nitty gritty choshen mishpat civil law, that holds the key to gaining a greater appreciation of the Ribono Shel Olam. Something that is impossible to fully know, but is also totally necessary, to try to accomplish. That's our purpose.
Why Mishpatim came right after Matan Torah.
Exactly. Which is something that all the Mefarshim emphasize. Ukamosha Amar, Yirmiyah Hanavi, listen to this. Yirmiyah said, Haskel, the name of the Haskel v'Yadoa Osi. The Ribono Shel Olam said to Yirmiyah, Haskel, use your intelligence, in order to know me. Ki ani Hashem osa chesed mishpat u'tzedakah ba'aretz ki be'elach hafatzti nu Hashem. So the drasha is that if you want to know me, you have to know my laws. Not my esoteric ritual laws, my nitty-gritty, practical, efficient laws. How could someone, through his intellect, really gain knowledge of the divine? Theologically impossible. It's impossible. The answer is through examining the details of his law. Hashem asa asela, v'zeu shenemar don din ani v'avion az tov. Alohi hadas osi ne'um Hashem. If you want to know me, you have to study my laws. Obviously, if kosher mishpat is primarily about efficiency and and stability, that doesn't make any sense. Just give me one more minute. Uksib b'makom acher ma Hashem doresh mimcha ki masos mishpat v'avas chesed ki adinim hem shoresh gadol laTorah. Civil law is the foundation of the Torah. Mehem nishtes ha'olam, and it is the pillar or the stable, stone of the world. Kamosh Amar Medrash Ksiv, exactly what you were talking about before. Lifnei aseres adibros, right? V'shaftu sa'am b'choles. Ksiv la'achar aseres adibros be'la mishpatim, right? And so on. So this idea of Rabbeinu Yonah is very obviously spectacular idea, but it's even more spectacular when you consider that the more famous Perush of Rabbeinu Yonah in Avos, the one on Omed and Kayam that the Tur, made famous, emphasizes exactly the opposite. It emphasizes the pragmatic part of civil law, of Jewish civil law. What's the answer? The answer is that both are true. And what's also true is that so this is I believe, the basis of explaining, the Nitziv's question against the Ramah and the Ramban. But to accentuate it further, and I'll take the question in just a minute, just one other Gemara very quickly. And that is the previous section on, what is it, page 5 or not? or 4?
Page.
Talmud Bavli Brachos Vav Amud Aleph. What page is that
5.
on? 5. Okay. So this is a Gemara in Brachos. Gemara says, "Minayin l'shlosha sheyoshim b'din sheshchina imayim." How do you know that 3 judges sitting in judgment sincerely, that the indwelling presence of the Rabbanu Shalom, no less, right, is there with them, right? Meaning that this is a spirit. Another way of saying, this is a spiritually significant enterprise. Now, what are they doing? Somebody came to them and said, "Shnai Mosam Batalis," you know. And they're going to say mana, you know, or called Alam Gavar or Yachloku or whatever they're going to say, or some other din Torah about theft or damages or something about a loan, right? But if there's these 3 judges in civil law, if they're sitting, you know, and they're using their expertise wisely, then the Rabbanu Shalom is with them. Shkina imayim. Wow. Shenemar B'kerev Elokim Yishpot. Again, Elohim Elokim. Uminayin l'shnayim sheoshev oskim b'Torah sheshchina imayim. 2 people learning b'chavrusa. Okay, that we understand better. They're learning Torah. Shenemar oz nidbru yirei Hashem isho re'eu, and so on. So let's skip a line or 2 for a moment. So the Gemara says, okay. This is 3 lines from the bottom. If 2 people sitting and learning Torah, Shechina Imayim, then what's the chiddush to tell you that 3 judges who are adjudicating the Shechina's Imayim? Right? More people doing the right
But
thing.
they're doing a mundane thing rather than learning Torah. So that's not the same.
Okay, but they're obviously adjudicating according to Din Torah, so there's an element of
Well,
leeway.
I mean, Talmud Torah can Kulam. I agree with Andy. I mean, just because they're there with
Right,
Torah doesn't mean that they're
right. The judges don't magically know the law, right?
No, I'm not agreeing with it. I'm just saying I understand the Havamina. Why
Okay, but it's even better the way the Gemara has is. You're right, but the Gemara is even better. Mao desema, Dina Shalma Bialma. So this in one pithy sentence, the Gemara in Brachos kind of captures exactly what we're talking about here. You might have thought it says that civil law, Jewish civil law, you know, is Torah, but it's a Torah of Shalom. I mean, it's more pragmatic. It's more about efficiency. It's more about stability, right? Having a coherent society, right? But Veloasya Shechina, as important as that is, because you can't accomplish anything spiritually significant if people are killing each other, but the content of Jewish civil law is more shalom than Torah. Kamash Malan, the Dina Nami Hainu Torah. That's not true. The din is Torah too. So that's, I believe, the answer.
Or you could say the essence of
the
Torah.
Mitziv's question. One second. What is the Mitziv's question? Mitziv said, if the Ramah was right, that according to the Ramban, Bnei Noach are the preference is not only to have a system as extensive as Jewish law or parallel to it, but actually our system itself. Then what do we mean when we say Magid Varav Yaakov, only to Yaakov, Chukava Mishpatav Yisrael, only Yisrael, Lo Asachein Lechol Goy, Mishpatim Bal Yidaum. They don't know the concept of Mishpatim. Hallelujah. Oh, we're praising Baruch Shalom for privileging us alone to know, Mishpatim that, are Magid Varav Yaakov. So that it says if it's the same system, then what are we talking about? But I believe this goes back to what I was saying before, which is sometimes you can have the same content. And it's not so different, than what Jacob was saying, except that he was zeroing in on the personalities alone. That's only part of that. So the idea is that when it comes to, there are 2 aspects of Jewish civil law. The 2 aspects that Rabbeinu Yonah, accents. There's the Kayam aspect, which could be shared with Bnei Noach, meaning this is a good, fair, equitable, consistent, system, and it's pretty comprehensive, and and therefore that aspect of civil law that otherwise Ishas Chaver Chayim B'La'od, that the Kayam part applies to kosher mishpat, much more so than, or, to the exclusion of kachim and taros and zroim. They have nothing to do with kayam, but kosher mishpat has everything to do with kayam. And that's what Rabbi Yonah says in that last Mishnah in the first parak of Ovos. And as far as that is concerned, kishidineim, kidinenu, mostly, that's what Bnei know. That's why we think it's a really good system and very efficient and very fair-minded. And therefore, if we had our druthers, says the Rama, according to the Ramban, we would apply this. This would be what non-Jews would use as well. However, the second element, haskel v'yadoa osi, or not dina as shalma, as shalom, but dina as Torah, that has to do, right, with, the particulars that are exclusively applied to Jewish law, the hasra, the two edim, the three dayanim, the kol pelech, the kol ir v'ir, and many more. And it has to do with the fact that, the psukim in Shoftim say that ki pale mimcha davar, when you encounter, with the dayanim, the local dayanim, when they encounter a difficulty and they don't know how to proceed, you have to go to the Supreme Court, right? So ki pale mimcha davar ben dam ladin, ben din ladin, ben dam ladam, ben din ladin, ben nega lanaga, divrei ribos bisharecha, v'kamta v'alisa lamakom asher yivcha Hashem elokecha. That's where the Bezdin Hagadol, the Supreme Court of the Jewish people, sitting at the Lishkas Hagazis in the Beis Hamikdash, you have to go to them, for they're the ultimate authority. But what's fascinating is, it's and the Gra makes this point, it's Ben Dam Ladam, it's Ben Nega Lanaga, in addition to Ben Din Ladin. Like, you could have thought that, like you have experts in, in Taharos, and experts in Hilchos Nida, and then you have experts in Jewish civil law. And especially, you might have thought Jewish civil law, that's like a whole different, perspective. That's really more about shalom, about efficiency. But it's not true. You go to the same Supreme Court, right? There's a holistic knowledge that they have to have. They're the authority for everything. It's v'kamta v'alisa. Because in addition to the efficiency, there is also haskel v'yadoa osi, the other, point of Rabbeinu Yonah. And Ramban totally understood this as well. That's what the Ramban says in Parshas V'aschanan. The Torah says, V'asisa hayashar v'hatov. So the Ramban there says, how come the Torah gives us so many details, and then all of a sudden, here and there, they give you these broad, like, platitudes. They're giving you this detail and that detail, and they say, do the good and righteous. What do you do the good and righteous? Just told us this is how you judge, Nezikin, and this is what happens for Shomrim, and this is what happens, in an interest-free loan. All of a sudden, V'yasisa Yosher Tov, do the good and righteous. So the Ramban says, it's like Kedoshim, Parshas Kedoshim. He compares the two. He says, the Torah gives you details, don't do this, don't do that, do this, do that. And then it says, Kedoshim to you, be holy. That's like a general statement. It's like a platitude. What do you need it for? The answer is, says the Ramban in both places, because there is the strict letter of the law, and then there's the spirit of the law. But the spirit of the law in halacha,
when you can fool Hashem, when you can Kedoshim to you, don't there's always ways to twist things.
Yeah, exactly. Altin aval b'shus haTorah. Don't be, don't try to narrow and limit. I'm not allowed to do this, but I can do up to that point. Right. I'm supposed to do this, but I'm not going to do any more. Kedoshim to you, like number one, the detail. Details are very important. One of the unique features of Judaism is that there are details. But when you have details, and you have also a broad principle, so you know how to extract the values of the details and then apply them, in a way that also the spirit of the law matters. That's what Shabbos is. That's the Ramban says he connects three different psukim. Kedoshim to you, Vasisa Yashar Vatov in Choshen Mishpat, in civil law, and the Mitzvah Say of Shabbos. And one is in beginning of Kedoshim, the other is in Emor, that's the Asay of Shabbos. And in Vaskana, it speaks about Vasisa Yashar Vatov. So what he says is, the Torah wasn't going to write down every contingency to happen. It couldn't. I would add, it probably didn't want to. It wanted man to take some responsibility too. So what it does is it gives us a lot of details, and we're supposed to extract the principles and the perspective and the values from there and apply them as well. So even if it isn't a technical law, that's how you're supposed to look at the law. So that part, I think I mentioned the Rambam in Sefer Mitzvos wants to explain why it is that umdana, circumstantial evidence, doesn't work in capital crime, right? I have it here in the Marmkom. It's not going to read it because we're already late. So in Mitzvah Reish Tzadi, so the Rambam says, the famous case of Shimon ben Shetach, that you follow one guy is running after the other fellow with a knife, and he's threatening to kill him, and then he corners him, and you lose sight of the two of them for a couple of minutes, but he corners him in such a way that it's easy to reconstruct what happened. By the time you catch up with them,
the bloody.
One fellow is dead, the other fellow is standing over him, and the blood dripping, from the knife or the sword or whatever it is. That's the famous Shimon ben Shetach who said, "What can I do? I didn't see you actually kill him." So we don't allow circumstantial evidence, to convict in a capital case. There are other ways to get at this fellow, but that's not for now. So the Rambam wants to explain in Mitzvah Reish. Just look at it for 1 second. And then we'll pick up with the Gemara and start. I'll give you Numar Makolos next. This is the Rambam on page 2, I believe. You have Mitzvah Reish Tzadi Dalet. Reish Tzadi, sorry. Yeah. Losase Reish Tzadi. That's on page 2. So the Rambam says, He shall tironu shalolachto chagadorim ba'omed adas hechazak. Even if you have a very strong circumstantial evidence, you could use it in dini momentus, by the way. You can use it in monetary cases, but you can't use circumstantial evidence in a capital crime. Even if it's very compelling, you're pretty sure this is what happened. One man's, clearly threatening and is on a murderous rampage against the other. In order to save himself, he backs himself into a corner. He runs into an enclosed place, but where there's no way out, unfortunately for him. And the other guy, you see him going in. But we didn't see the event. We saw right? You could see the blood dripping from the Erev. Besono shayirod for Omed Olav V'Sakan Biyado Shneim Menatfim Dam. Hinei Zeharodef Lo Yahargu Sanhedrin Al Tzad Chituch HaGeder Achar Shein Sham Edim Me'idim Sharo Ariga. You can't formally charge him with this crime, even though we're very convinced what happened here, because you didn't see it. Boaz Harabatorah, right? B'Toras Ha'emes, right? Meharogzeb who amaro v'naki v'tzadik altaro kilo atzdik rasha. So the Rambam, wants to explain why this is. So I'm going to skip a little bit. So he says, number one, he says basically two things or overlapping things. Number one, whenever you have circumstantial evidence, that is very compelling, so there's also circumstantial evidence that's a little less compelling, and a little less than that, and a little less than that, meaning there are levels of compelling circumstantial evidence. So the Rambam says, if you start using the most compelling circumstantial evidence, it's a slippery slope until you, extend it just a little bit to, from 95% to 90% to 85% to 80% to 75%. And then, you're going to cross over the line because obviously, the possible other alternative, scenarios are something.
There's also another factor, like when President Reagan asked Moshe Feinstein about capital punishment, he said that we also believe that the Roneshon intervenes also. So
that's the compensation for sure.
Yeah. So
yeah.
If he
So
doesn't get punished by us, he's going to get punished by
yeah,
some.
yeah, no, that's a very important principle in Chazal for sure. Um, we don't think, in the end, we do believe that there is justice. But okay, that's one thing. But then the Rambam says something else, and that is, that in the end of the day, says the Rambam, it's better that 10, guilty criminals walk than one innocent, misunderstood person, be irrevocably given the death penalty. And that's this line in the Rambam. He says, here, maybe I should skip because that's when here, one second. Oh, he says, Kasher lo nachto chagedorim b'dimyon chazak me'od, if we decide not to apply, um, circumstantial evidence, so there's a downside hugely in terms of deterrent, in terms of justice. Hine tachlis mashi yesh and iftar achote, we're going to let the criminal walk. Obviously, that's not a good thing. But on the other hand, the alternative is, right, if we follow the circumstantial evidence, hine pamim, sometimes narog noki, right, yom echad. Sometimes, very rarely, we'll make a mistake and we'll kill the wrong person. And then he adds, this is the key line, ulazakos elef chotim yoser tov v'nichsaf, right, meharog zakai echad yom echad.
Well, isn't this a delineating line between Dine Mamonis and Dine
No,
Nefesh?
this is. I'm talking about Din Nefashos. But I want to highlight here is the following. This is something unique in Jewish law, based on the Mishnah in Masechet Makos on Zayin Amud Aleph. I mean, this idea that, what is a greater priority, the law and order part, let's say, or the, ensuring, that you don't have a miscarriage of justice on the level of killing somebody, improperly. So that has to do with Kedusha Sa'adam, and that has to do with the Kedusha of the system. That's what we mean when we say that what differentiates Bnei Noach and Klal Yisrael is Eda v'Edim v'Hasra'a, Pelech u'Pelech, things like this comment, of the Rambam.
Concept of
As
motion
pragmatic as
witnesses.
civil law, including, capital crime and so on. That's all part of the criminal legal system. I'm just using this as an example. This is where the Davar Shebekdusha, we'll call it, comes in. So the idea is, afilu k'shedineim k'dineinu, the fact that Choshen Mishpat is the source of Yedias Hashem, that it is, to put the Barbanel also has a very nice comment in Shoftim. Barbanel says, as much as Choshen Mishpat helps you to stabilize society, it's important to know that it also is intrinsically significant, and it has the Davar Shebekdusha. So in that respect, as much as there's overlap, there's different. And that's why afilu k'shedineim k'dineinu, you still need dayanim who are Elokim Elohim, and you still are limited, all things being equal, to Jewish law. So what does this have to do with us? And then I'll take the question. So I think what the answer to the Ramban is found in the Rabbeinu Yonah and in the Ramban himself. And that is, why is it important to count, individually, these institutions of civil law? Why not just say, kind of like we do with the Ben Noach? The answer is because the details, even of Jewish civil law, highlight values. They're the basis for V'yasisa Yashar V'hatov. They are the basis of Haskel V'yadoa Osi. And that's what the Rambam meant, and that's what the Ramban ultimately went along with. And that is, it's true these aren't do's and don'ts, but what they are, the institutions illuminate the Jewish law perspective on so many different issues, including kaskas kashrus, when do we believe people, how do we, separate, between, different seemingly equal claims, what do we give priority to, in a towing v'nitan, in a litigation, In addition to being efficient, these are also principles of sanctity.
Of poor people, widows, orphans.
Well, that's to losata mishpat and so on. But there was a question. Yeah.
Rob, how do we reconcile uh, with Dina de Malchut Adina? And what I mean by that is, as you mentioned, the civil courts can arrive at the same conclusion and both be right. But the tools that they use, for example, you mentioned that our courts require 3 dayanim, 2 edim, civil courts don't.
Mm-hmm.
The question is, why do we defer, if you like, Dina to the Dina de Malchuta, if there's really no fundamental, shall we say, objection, contradiction, or whatever?
Well, Dina Malchus Dina is a very interesting topic in its own right, and we're certainly not going to discuss it, extensively now. But mostly, it's a concession, although a principled concession, to living in a non-Jewish, society, and respecting the laws of the land. Meaning, if like if there's no if the government that you live in, and especially, by the way, Dina Malchus Dina, according to many of the Rishonim, it's not
fair.
it can't be arbitrary. It's not Dina de Malka Dina, right? It's Dina de Malchusa Dina. So the prerequisite is that it be reasonable and fair and consistent. But if you have reasonable, consistent laws and they govern a certain society, and you live there as a ger or a toshav or both, so then out of respect, and akaras hatov, and proper citizenship, to the place that you're living, you can't violate, the laws of the land, as long as they don't interfere with Dinei Torah. So when there's a clash in Choshen Mishpat or something like that, there's always much more flexibility, because you can always decide, two people can always decide to suspend their rights. You know what I'm saying? What we call mechila or lebater. So Dina Malchus Dina doesn't allow you to be mechal Shabbos.
No.
The government. Right. No. I'm not saying. I'm explaining. So what I'm saying is, it's an add-on, and is a concession, but a principled concession to being a good citizen, and not abusing, your privileges in another country. But it would only apply to things like, for example, usually it's neutral areas. It's not usually issues where there's any clash with the halacha. For example, paying your taxes, right? So if somebody, cheats on their taxes, that's a violation of Dina Malchus Dina, because, there's no halachic reason that.
No, I appreciate that, Rabbi, but what I was getting at is the tools, the framework that is required to arrive at a psak, whether the psak is civil or the psak is beddin. What I mean by that, if, for example, judgment is rendered on the basis of the edut of one person as opposed to two,
that but Dina Malchus Dina isn't about that. Dina de Malchus Dina is respecting the laws of the land. It's not about adjudicating, necessarily, unless that's the law of the land. It's not about adjudicating disputes in the local court system, right? Like, the government doesn't care if if you have a din Torah, and you there are all sorts of mechanisms for dispute resolution, outside of the government. Government courts and civil legal issues are optional, but if the two of us agree, two litigants agree, that we're not going to go to court, we're going to settle privately, the government has no problem with that. And so too, the government has no difficulty with, deciding, the two of us deciding that we'll dispose of our argument, right, in a religious court, as opposed to civil, unless they do for a particular reason in a certain area of the law. It's more like, there are laws on the books, and there are certain definitions, things that affect other people, or your status as a citizen. Um, like there are laws, you're not allowed to be a public nuisance. You're not allowed to, as I say, you're not allowed to avoid paying, your fair share as a citizen. You're not allowed to, behave in a way that interferes with the quality of life of your neighbors. All these things that are even the parts, let's say, they're not addressed by Jewish law, or there's no contradiction to being, to the Jewish law requirements and the secular law, requirements. So that's where we apply this principle that
For us, the
you are
departure.
obligated to be a good citizen and to respect the laws of the land in which you live, as within reason, as long as they are A, fair and not arbitrary, and B, they don't contradict the prohibitions of the Torah. And as long as they're in civil law area, there's always added flexibility, anyway. So there's no contradiction. The problem of one witness, two witnesses, how many judges, that's not usually relevant to Dina de Malchus Adina.
Okay, that's what I wanted to know.
Hearing, right. It's adhering to the laws on the books.
To my mind, the departure is succinctly stated in the Torah, that is tzedek tirdof.
We'll talk about the next week.
The methodology, as well as the goal, have to be tzedek.
Yeah, that's true. Very good. Do you get a mazel tov?
I do. Thank you very much. I have a grandchild.
I heard that you had a grandson and a bris.
We had Thursday past the Brit. Noach. Noach is his name.
Oh, okay. I think the Mohel lives in my neighborhood.
He does, and we had a brief discussion that how lucky he is that he's near you.
Oh, thank you. So he told me the good news, so I'm happy to wish you a mazel tov and only simchas.
Yes, it's Alex Weiner was the Mohel.
Yeah.
And he did a great job.
And what's the name of your grandson?
Noach.
Oh, so you should have a lot of
Mori.
From him and from the rest of the family as well.
Thank you so much.
Okay, so we'll continue next time. I'm sorry we didn't get back to the Gemara, but we'll start going straight in the Gemara and discussing when you say achloku, when you say the others, more conventionally, now that we finished our introduction a little bit about the nature of Jewish civil law as it relates to Tony Benitzon, we'll be better equipped to appreciate some of the choices, that we make in terms of psak, and to understand them not just in a technical way, but also as values moving forward. Okay, so
thank you. Good night, Rabbi. Thank you.